Hey, I got a lady. Hey, I got a lady. Hey, name is the upper echelon. She a debater, baby. She can give it to you straight, no chaser. She got the smarts. She got the heart. She got the confidence. Yeah. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. 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 Hey, I got a lady. Hey, I got a lady. Hey, name is the upper echelon. She a debater, baby. She can give it to you straight, no chaser. She got the smarts. She got the heart. She got the confidence. Yeah. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. 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 Hey, I got a lady. Hey, I got a lady. Hey, name is the upper echelon. She a debater, baby. She can give it to you straight, no chaser. She got the smarts. She got the heart. She got the confidence. Yeah. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. She got the smart. She got the heart. She got the confidence. Baby, she the upper echelon. You know you intimidated. Stupid can't play with smart. 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 Stupid can't play with smart.
Welcome back to the Upper Echelon Podcast, where we keep it real and we keep it jiggy over here. Because why? Because we ain't never ever scared. Hit that like button on your way in. Please hit the like button for me. Make sure that you're subscribed to my channel if you're in here. If you watch me on a regular basis and you haven't subscribed yet, why not go ahead and subscribe to my channel, please? I want to say thank you to those who have already assisted me in getting towards my goal That would be Teresa Frazier. Thank you so much for that super sticker. I appreciate you. Thank you so much, Coach. I appreciate your support. Thank you so much. Where am I at? Where am I at? Marcella, thank you for that membership. I appreciate you. Okay. Let's get into it, you guys. Let's get into it. My bad, y'all. I had to take care of something really quick. Okay. Who is in the room? Who is in the room? Let's see who's here. We're gonna get into a couple of things, y'all. Okay. First, I do want to, before I get started, it's a lot of y'all here, so I don't have time to do individual shout outs, unfortunately, but thank you everybody for being here. First, I do want to read my pinned message, which says, welcome everyone. This is a space for respectful discussion and learning. Different opinions are welcome as long as we keep things kind and factual. Okay? Keyword being factual. Okay? Disruptive behavior, meaning anyone that comes into my chat can give a different opinion. However, you're not going to be arguing in the chat with the host. That I will not be doing. Okay? So I won't be going back and forth. And if I see that you are interested in going back and forth, I will be removing you from the chat, or one of my moderators will be removing you from the chat, because that is a distraction. Okay? Now, let me get into my disclaimer before I get into the commentary. Copyright disclaimer under Section 107 of the Copyright Act of 1976. Allowance is made for use for purposes such as criticism, comment, news reporting, scholarship, and research. Everything in this live stream is for entertainment purposes only. Okay, so let's get into it, y'all. So tonight we are going to be talking about Holly supporters and how they are purposely attempting to intimidate the witnesses. Okay, we're also going to get into the difference between what is legal and what is moral, and if posting the photo, legal name, and other information about a witness in an active and open unaliving investigation is legal, or if it is illegal. And we're going to get into that topic. We're also going to go over a couple of things that were stated in the motion. Before, and let me just add on that I read Ari's motion, and I read it again, and I read it again, and I read it again, and again, and again, and again. Okay? And from what my opinion about the motion is that it's very, very, very weak. Very, very weak. The defense case in general is very, very weak. That's my opinion, and I believe that it won't take much for the prosecution to knock that motion out of the box. I'm sure that it'll be denied and thrown out, and I'm almost positive that Quadajah will remain behind bars, as I've said for the past 2 court dates. So let's go ahead and get into the commentary. Thank you so much, Comic Collective. I appreciate you for always supporting my channel. Comic Collective says, thank you for always coming with the truth. And thank you for your support. Let's get into it. Hey, Raw Non-Biased, what's going on? Lady Love, hey, all my mods, Sweet Queen, all my mods, welcome in. So, let's get into a couple of things before we get into witness intimidation. I want to slow roll this thing a little bit because I want you guys to get a full understanding of what occurred recently as far as the very, very reckless behavior of posting the state witness in an open, unaliving investigation is so detrimental to the defense. So we're going to get into a couple of things and see the first thing that we're going to pull up, because again, we're not working on feelings or emotion on my channel, or what we think should happen or what we believe should happen. We're going to focus more on the paperwork, the documentation, and the law over here. So give me 1 second, you guys. Let me pull up this document. Okay, you guys, I'm trying to pull it up for you. Now, this is a document. This is a document that I did show you guys on a previous live stream that I did. As you guys know, I was the first creator to go ahead and present the motion directly after I did the presentation of the motion. My channel was fraudulently reported, and then it was put right back up, of course, but it was fraudulently reported. But I just want to say this. Regardless of what information that I obtain, whether, I believe that it fits my narrative or whether or not it doesn't fit my narrative, I'm going to present it to my audience, because I believe that there should be a certain level of transparency if you're reporting on a case as serious as this. I'm not going to hide certain documentation from you, because I think that I would have some sort of problem in defending the narrative that I'm trying to present to my channel, which is the reason that I myself presented the motion to Holly supporters. So Holly supporters are aware of the motion because I presented it, right? So there's nothing that I'm going to obtain in regards to this case that I can legally present as far as public documentation that I'm not going to present, because I don't want it to go against whatever narrative that is supposed to be happening over here. There is no narrative. There's the truth over here. So the motion was presented, and the motion is obviously written in Holly's favor because her attorney wrote it. So of course it's in Holly's favor, but I'm not going to hide it from my audience. I'm going to present it so that Holly supporters who didn't have the documentation can see it, and so that Romeca supporters who don't have the documentation can see it, right? So I'm presenting everything over here because there is nothing to hide, right? So, you know what? Before I get into that, I do want to give y'all a brief summary of the last court date. No, I was not present at the court date. However, I do have a very, 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 and no, it is not a family member, reliable source who is keeping me updated on documentation, keeping me updated on what's happening in court, taking notes for me, speaking to the correct people, and returning that information to me so that I can present it to the audience. Okay, this person is non-biased. This person is a professional, and they are simply giving me the information to present. Okay, so I did receive a summary the other day. I just didn't present it because I was distracted by other things. So let's get into the summary real quick before we hop into the commentary. So as you all know, on December 23rd of 2025, there was a status hearing that took about 5 minutes. Ari Williams, who is Holly's attorney, claimed that she notified the prosecution of her motion at the last court date and asked him if he would be able or if he would be willing to allow it, and he said no. She said, well, I'm letting you know I'm filing it whether or not I move forward with the motion. I'm still going to argue it before the judge. So she said then that she emailed the state on 12/22/2025, and records show that she filed it 12/22/2025 at 3:37 p.m. to be on 12/23/2025. Only proof was that it was filed, but there was no proof that it was actually emailed. The judge did not want to hear the motion on that day and saw it necessary on that day for Quadajah to remain in custody and ordered that the motion be heard on January 7th, 2026. The state asked for DNA, or the state asked for a DNA sample from the defendant, who is Quadajah. Ari Williams objected to that DNA sample in stating that it would violate Quadajah's HIPAA rights. The judge then overruled that objection because, as you guys see in the documentation, it does say that an order was put in place by the judge for Illinois State Police to do a buccal swab and DNA testing. Now, I was already aware of the grand jury being held on November 20th. However, my direct source was able to get in contact with the assistant state's attorney and was informed with limited documentation that the grand jury officially returned the indictment on December 22nd of 2025, which is why you see where on documentation it states that it was superseded by direct indictment, and the case number for the indictment is, and it gives the case number. This is the grand jury indictment. Please look up direct indictment. Although the grand jury conveyed on November 20th of 2025, they had not yet returned the official indictment yet. Now, January 7th, 2026, the case will be transferred to the criminal division for arraignment. The case will then be assigned to the trial judge and the prosecutor that will be handling the case on that day. The motion for release by Ari Williams will be heard. As on December 4th, 2025, Judge Costello did advise Ari Williams that detention can be reviewed at each hearing. My source stated that she highly doubts that at this level, any judge will overrule their colleague, not to mention that her charge is first-degree unaliving. Okay? Not only is what my source says, is the community and witness safer with her detained, so is she. Goes on to say, there probably will not be another court date for another 14 days, and it will probably be another status hearing, end of January or early February, depending on the judge's calendar. Let me keep going on. The defense does not have all of the evidence as of yet. She's only been provided with what was mentioned in the proffer. I'm redacting some things that are being said, y'all. That's why I'm pausing. The smoothie shop was not mentioned and has 3 cameras. After the 7th of January, they will then exchange evidence and she will file her motions to suppress. That is an area that Ms. Williams is good at, procedural errors. She is not well liked, and her attitude and reputation supersedes her. Okay, so I'm not going to finish reading the rest of that. So that is what happened on the court date on December 23rd. And then I also gave you the information about what is going to be happening on January 7th of 2026. So now we're going to move on. Now, the issue that is at hand that's being called into question is it okay? Is it legal for documentation to be not documentation, but pictures and legal names to be provided of witnesses in an open an open murder case. Now, let me pull something up for you guys, okay? I'm gonna read this first. Now, this is documentation that you guys have already seen, but we have to go over this again as a reminder. Let me just do this really quick. Thank you, Philly Girl Juice. I appreciate you for helping me get towards my goal. Thank you so much. Thank you, Josephine, for the membership. Tanisha, thank you for that membership. Lady Love, thank you for your 14-month membership. I appreciate you. Thank you, Rolanda. I appreciate that. Thank you, Chandrika. I appreciate you. Okay, so let's get into this really quick. Now, the reason why it is very detrimental, we're going to get into the legal aspect of it in a minute, but the reason why what Holly's supporters did was very detrimental to her being released is because, as you guys know, one of the reasons why Holly was not released in the first place is because the state of Illinois is saying that Holly is a danger not only to the community, but also to the witnesses. First of all, when you are charged with first-degree murder, there is no question of whether or not there is a possibility that you are a danger to the community. Quadajah opened fire in the presence of several people in broad daylight, less than 500 feet away from the physical property of a school building, with her child in her car. Okay? So, because of those known aspects of the case, it would be beneficial and safer to keep her incarcerated pre-trial. It doesn't matter about, and we're going to go back over what Ari stated in her motion and why I feel that it is a very weak defense. And if that's going to be Ari's defense, I don't think it's going to be looking good for Quadajah. Now, when we look at the order after the pretrial hearing, it clearly states here that upon hearing the state's petition to deny pretrial release, the court finds that the state has shown by clear and convincing evidence that the proof is evident on the presumption great that the offense listed in 725 ILCS 5/110/6.1. Okay. And we're going to go over what that code means as well. So the state is saying because she is guilty of what exists within that code, she should not be released. And legally, they are able to keep her detained. Now, one of the things that Ari stated inside of her motion was that Quadajah does not have a history of violence. She does not have a long criminal history. So due to the fact that she doesn't have a long history, and due to the fact that her rating on the risk assessment scale is only a 2, then that is what she's arguing as far as why Quadajah should be released. And I'm going to go over with you all why that doesn't matter and why the state does not have to release her just because her risk assessment is low. Because her risk assessment is low does not mean that the state of Illinois has to release her from custody pre-trial. Now let's get into this before we get into the code. Make sure y'all hit the like button for me. The proof is evident and the presumption great that the defendant has committed an eligible offense within the code that I just read off to you guys. Defendant and victim each have a child with witness 1. All parties got into a dispute near a school. The defendant threatened victim multiple times in front of witnesses. Defendant had retrieved a handgun, shot victim multiple times in front of witnesses, and the victim succumbed to her injuries. The defendant is a real and present threat to the safety of any person or persons in the community. Let me stop here and say that even if the content creators who are sabotaging Holly's case unknowingly never would have posted the witnesses on their social media and community walls or Facebook or whatever, it still wouldn't have even mattered. The state of Illinois would have still believed that the defendant would have been a threat to the community and the witnesses just based off of the charge and what she has been accused of and what she has admitted to doing. Okay? Based on the meaning she's been accused and she's admitting to, from what we know so far, killing someone in broad daylight who was unarmed. There's a lot of things that haven't been presented that we don't know. But what we do know is that Quadajah killed another human being who did not have a weapon of the same force to use against her in broad daylight in front of multiple people within 500 or less feet from physical school property, with her 7-month-old child less than 5 feet away. So even though there's several things that have not been gone over yet in this case because it hasn't reached trial, the state knows enough to say, we believe that this person is a threat to the community based off of her actions, which led up to this charge. Y'all following me? Okay. Now, the defendant murdered victim. And so I just want to say this for the people who are arguing and getting upset with me for calling Quadajah a murderer. Not only am I calling Quadajah a murderer, not only am I saying that what she did was murder, but the state has also said that we strongly believe that she's a murderer. They've called her and labeled her a murder on court documentation. And that is what she's being called by the state of Illinois. So when I call her a murderer, it's not speculation, it's not emotion, it's not opinion. In fact, it is a documented fact that she, according to the state of Illinois, is a murderer. So I'm not having that debate with anybody. I'm looking at black and white documentation. The documentation states that Quadajah is a murderer. She's going to have to prove that she isn't a murderer. But until she does prove that, the state of Illinois suspects her of being a murderer, so much so that they placed it in the documentation and charged her with it. Now, I'm not having that argument with anybody anymore, okay? So the defendant murdered victim after victim had just dropped her child off at school. The defendant celebrated the murder immediately after. Defendant was undeterred by the presence of witnesses, public setting, broad daylight, near a school, and near many children. Multiple civilian calls to 911 before and after the murder. Okay? Number 3, no condition or combination of conditions set forth in the law code that we are getting ready to go over after this can mitigate the real and present threat to the safety of any person or persons or community based on the specific articulable facts of the case. Less restrictive conditions could not avoid a real and present threat to the safety of any person or persons or the community based on the specific articulable facts of the case, because electronic monitoring and home confinement could not deter defendant from harming the witnesses, committing new offenses, or complying with conditions of release, as electronic monitoring / home confinement require a high degree of compliance with rules to be effective mitigation. The defendant showed utter contempt for law and basic social norms, and she did, because it is not normal. I'm gonna continue, but I gotta put my commentary in there. Hey, everybody coming in the room. It is not normal for any person, according to societal norms, to get into a physical, well, not physical, but I'm gonna say possible physical altercation, a verbal altercation, and then be able to walk away and shoot an unarmed person due to that altercation in broad daylight around children, including their child, that is what they're saying is not normal. This is not normal behavior. Let's not forget that after Quadajah did it, she was arrested and then set free for about 80 plus days. During that time that Quadajah was free, Quadajah was on social media. She showed no remorse. She was rubbing it in the family's face that she would be able to spend time with her family. She was posting OnlyFans. She was getting family members to post OnlyFans. And I'm going to tell you why that's important. Because if you think that it's not important, that during the time that she was not incarcerated, her behavior was definitely being watched. Behavior of someone who is remorseful would not be on social media promoting sex. They would not be on social media showing off a vacation, posting outings to eat when they are actively under a murder investigation for killing someone. That's also not normal behavior. So what that shows to the investigators and to the state now at this point is that she was non-remorseful. And what happens when someone is non-remorseful? When someone is not remorseful for their actions, when they don't think that maybe there was something that they could have done different, when they don't show that maybe there was a different way to handle the situation, that means that they may re-offend. If I do not believe that what I did was wrong, then I will do it again. If I don't believe that there was any issues with my behavior or how I processed or handled the situation, then that means that there is a high probability that I will get into another situation, possibly with another unarmed person, have a disagreement, argument, maybe even a scuffle, and think that it's okay to walk away, retrieve a weapon, and kill them. So the state releasing Quadajah from custody is telling Quadajah that, okay, you killed somebody, no big deal. That's not gonna happen. It's simply just not going to happen. And I think that it's asinine and ignorant to believe that it will. Also, I just want everybody to know, if anybody has a problem with my commentary, the way that I speak, or how I talk about Holly supporters, you know what? It's so easy not to hear it. Just don't come over here, and then you won't be bothered. But like I said, I think it's very ignorant. And when I say ignorant, that just means not knowledgeable. If you actually think that this girl is going to kill someone, she's been charged, meaning that more evidence needs to be presented in order to convict her, meaning that there is doubt that she's innocent. If there's any doubt at this point that she's still innocent of killing someone without just cause in broad daylight around children by a school, if there's any just cause or doubt that she is guilty, they're not going to release her. She's a danger to society. She may do it again. She doesn't think that what she did was wrong. She has shown no remorse. She doesn't think it's wrong. She was trying to be funny during the time that she was under investigation, but I guess the Meeks family got the last laugh because her ass is sitting up there in Cook County Jail where she belongs, and she's not getting out. Now we're gonna get into this law code that has been mentioned several times. Now Ari also mentioned this law code within her motion, and we're gonna go over that as well before we actually pull the code up. So it then goes on to say, for offenses under subsection B of section 407 of the Illinois Controlled Substances Act that are subject to 725 ILCS 5/10, the defendant also poses a serious risk to not appear in court as required. As you can see, this code here is all over the place. Let me go, hold on. This code is all over the place. It's here. here. It's all over the place. I'm just showing you how many times this code is placed within the documentation. This code is very important because it speaks on whether or not she should be released or if the state is required to release her. So let's get into, let me go up a little bit. Okay. Now I'm gonna, as I did before, pull up Ari's motion. And of course, because I'm not reckless and I'm not trying to get anybody killed, I will not be showing all of the witnesses' names in this documentation as I did before. When I initially showed this motion, I made the decision to pull down the documentation before I read any further because I did not want to put any of the witnesses at risk. And that's what I'm going to do today as well. So let's go ahead and pull this up, okay? Again, here, Ari also mentions this motion as a, is this Ari? No, this isn't the right one. Hold on, down. Give me 1 second. Okay. Okay, so here's her motion here. Ari also mentions this motion in her documentation, where she states that the state of Illinois has abolished the requirement that a defendant post monetary bail in order to be granted pretrial release from custody. She names that law code. She says this law was originally set to go on into effect on January 1st of 2023. On December 31st, 2022, the Supreme Court granted a supervisory order stating the effect of the pretrial release provision that abolished monetary bail in Illinois. However, on January 18th, 2023, okay, so then I'm not going to read all of that because then she goes ahead and she gets into all of the different cases in which, in the state of Illinois, that she selected to use as her sources to show, hey, look, in this case, this person also committed murder, was charged with murder, but they were released until trial. And then in this case, it also happened. In this case, it also happened. So she's using those as references to say that it can be done. She can be released. And according to her, she should be released. So let's get into what that law code actually means. Okay. And let's pull this down. So okay. Hold on, you guys. Oh, no, Angel, that doesn't mean that she had any controlled substances or that any controlled substances were, to this point, to our knowledge, were involved in the case. Oh, the reason why that was mentioned is because the name of the act is the Illinois Controlled Substances Act. And within that act, it states that if a defendant is a possible flight risk, or may not appear in court, they should not be released. But it doesn't necessarily mean that substances were directly involved in the case. So, okay, so let's pull which one again? Okay, so this is the law code that has been mentioned over and over and over again within a lot of the documentation. And that law code is 725 ILCS 5/110-6.1 from chapter 38, part 110/6.1. Okay. And the name of the code is the denial for pretrial release. Now, within this law code, it gives the courts and the state basically, I would say, lawful reasons to keep someone detained or reasons to have or to allow the person to be released pre-trial. So Ari also mentioned this within her motion, and I'm going to read a little bit more of Ari's motion, but we're going to go over what this law code said. Now, when I read over it, what I noticed is that both are right. The state is right for keeping her detained until trial. Ari also has an argument. However, Ari is missing something, and I'm going to go ahead and pull that up for her. So, number one, the defendant, okay, so let's start here. A, upon verified petition by the state, the court shall hold a hearing and may deny a defendant pretrial release only if the defendant is charged with a felony offense other than a forcible felony for which, based on the charge or the defendant's criminal history, a sentence of imprisonment without probation, periodic imprisonment, or conditional discharge is required by law upon conviction. And it is alleged that the defendant's pretrial release poses a real and present threat to the safety of any person or persons or the community based on the specific article facts in this case. Okay? 1.5. Oh, before I move on, I just want to highlight something real quick. Hold on one second. Let me highlight something real quick. Charge, defense, criminal history, assistance, other imprisonment without probation. Defense, pretrial release. Okay, 1.5. Let me move forward. The defendant's pretrial release poses a real and present threat to the safety of any person or persons or the community based on the specific articulable facts of the case. And the defendant is charged with a forcible felony, which, as used in this section, means treason, first-degree murder, second-degree murder, predatory criminal SA of a child, aggravated criminal SA, armed robbery, aggravated, and we're not going to read all of these, okay, because there's no need to read all of those. We know what she's been charged with. So we're going to move on. So this is saying, and let's read it a little bit slower. The defendant is charged upon verified petition by the state, the court shall hold a hearing and may deny a defendant pretrial release only if the defendant is charged with a felony offense other than a forcible felony for which, based on the charge or the defendant's criminal history. Now I'm going to highlight this part because this is what Ari is arguing. Ari Williams, the hood attorney, I'm sorry, I didn't mean to say that, but Ari Williams is arguing that her murderous client should be released because she does not have a criminal history. But the interesting thing about the law is that you have to read it very, very carefully because one word could make a huge difference, okay? And the word that makes a big difference here is a two-letter word which says or. Meaning that the state has every right to continue to keep Quadajah incarcerated until trial because in this law code, it states that the defendant is charged with, they are allowed to keep her incarcerated pre-trial if the defendant is charged with a felony offense other than or a forcible felony for which, based on the charge, which is first-degree murder, or the defendant's criminal history, meaning that the state does not have to consider Quadajah's lack of a violent criminal history. They don't have to consider that to keep her incarcerated. They can if they want to, but they don't have to. They can do either or. We can say we want to keep her incarcerated because she has committed a felony, committed first-degree murder. Or we could keep her incarcerated because she has a lengthy criminal history. But both of those things do not have to be considered. Ari is saying that she should be denied, that she should be released from incarceration because of her lack of a violent criminal history. But what the state is going to say is that doesn't matter, because according to the law code that you presented in your motion, it states that legally we're allowed to keep her incarcerated just based off of the fact that she's been charged with first-degree murder. Boom, in your face, bitch. The bitch ain't getting out. The law says it right there. It says it right there that the state, my bad, I didn't mean to say that, but the state legally does not have to release Quadajah if they don't want to, because just simply based off of the fact that she murdered someone and has been charged for it. Her lack of history of killing someone does not. I'll give you an example. Okay, so if you've never committed a violent offense a day in your life, but one day you wake up and say, I'm going to go, we'll use somebody that has a mental illness. So somebody has a mental illness, but they've never committed a violent offense against anybody. But one day they're spazzing out because they forgot to take their medication. So they go to the grocery store and they pew the cashier in the head because they're having a psychotic episode. So then they're arrested and they're charged with first-degree murder. And so then their attorney is going to say, well, they've never had committed an offense before. Do you think that they are going to let somebody out that committed a murder, regardless of what the excuse may be, whether the excuse is self-defense, mental illness, or whatever it may be? Do you think that they are going to just release somebody that has been charged with first-degree murder, with several witness statements? They're trying very, very hard to discount the witnesses, but it's weak as hell. Not only is her motion weak as hell, but the content creators that are trying to discount the witnesses, their stance is weak as hell. It's laughable, actually. Laughable. But their stance, I mean, the whole headphone, I just can't, I cannot. As a matter of fact, the fact that Ari even put the headphones thing in her motion shows that she don't have nothing. That's your defense? That she had on headphones? So it's not possible that she could have turned the headphones off but still had them on? It's not possible that she had the headphones turned off during the actual murder, but then they were on when she was talking to the police? Do you have proof that she had them on or off and when she had them on or off? If that's your only defense is a fucking set of headphones, then that motherfucker, Quadajah need a new attorney. If that's all she got, if that's all she has, and then the other thing, none of the witnesses saw the shooting. No, let me say this. It doesn't matter. Even if that's true, which I don't even believe, but she has to do what she has to do for her client. So keep in mind, when you listen to Ari's motion, Ari is Quadajah's attorney. Ari is going to put whatever in that motion to defend her client. She's desperately trying to get her released from custody. So of course it's going to be in her favor. Okay, weak ass defense. It don't matter if Casper the Ghost or Boo Boo the Fool didn't see the damn shooting. She admitted to the shooting. It doesn't matter that nobody saw it. There is evidence that is stated in the proffer that witnessed that captured video and footage of the baby daddy holding the victim in a headlock moments before the shooting, meaning that during the shooting she was not being actively accosted or attacked in that moment. It doesn't matter who saw it at all. It could have been nobody there. It could have been nobody but that camera that saw that. The fact that she murdered someone as they were being restrained, as seen by the camera, that's all they really need. Even if they got rid of all of the damn witnesses. The girl said herself that she shot and killed Romeca. Romeca was unarmed. There are several things that need to exist. And this is the thing that I think that a lot of people that do support Holly, they are very much so in denial about, is that the number one thing, and I've been saying this from Jump Street, that is going to be presented and taken into account. And that this is the number one thing that's always presented and taken into account anytime there is a killing with a weapon. When a person says that they are defending themselves, the number one question is, was the person armed that you murdered? And if so, armed with what? Was the person armed? That is going to be one of, in my opinion, the biggest deals in this case. This girl was unarmed. Ari also harps on, we're going to get to the reckless content creators in a minute, but I want to speak on this too. Ari was also placed inside of her motion that Quadajah, matter of fact, I'm going to read it. No need to pull it back up. Let me read it really quick. I want to go down to, it's very weak. The motion is weak. The motion is weak sauce. Matter of fact, I laughed at it when I read it. The whole time I read it before I presented it, I laughed at it. It's a joke. The whole motion is a joke and desperate, very desperate. I mean, she wants her out, but it's weak. Let me go down. Go down. I'm trying to find where I should have put it. I should have check marked it. She says notably, and she has to say notably. The reason she said notably before she starts this sentence in this motion is because the jury and the prosecution are going to harp on this. She says in her motion on, what page is this? Page 7 of her motion. Notably, yes, on September 8th of 2025, that was the first in-person encounter between Ms. Johnson and the victim. That is going to be a very big deal. There's several, I read a status today. I don't know who said this, but a creator that I follow posted on her community wall that somebody said that Quadajah did everything by the book. I spit out my damn water. I spit my water out. Did everything by the book. Quadajah did everything wrong that day. The number one thing she was supposed to do is call 911. That's the first thing she was supposed to do. She didn't do a lot of things. The second thing that she was supposed to do was to get in her vehicle if she felt threatened. But we're going to get into that later. But she definitely didn't do everything by the book. As a person that is concealed to carry, you have the responsibility to de-escalate the situation. You have the responsibility to do everything within your power. And everybody that is concealed to carry knows that. Everything within your power to not use your weapon. You don't have a concealed to carry and use it like you in the movie Tombstone and it's the Wild Wild West and whoever talking slick or say they might whoop your ass, you pull out and pop them in the face. What planet or universe are y'all living on? That is not how it works. That is not by the book. That is not the correct procedure. She did not call 911. Not once is she on record calling 911. The law even says that when you obtain an order of protection, whether it was given to her or not, when you given to Romeca or not, once you obtain an order of protection, you know there's rules for the petitioner, right? You do know that. One of the rules is that you are expected to call 911 if the person that you got the order of protection against violates it. You know that that's the law. So when you say that she went by the book, no, she didn't. The law says that she was supposed to call 911. At her initial detention hearing, the judge asked her why she didn't call 911. The judge also made note that there were several moments in which she could have called 911. The simple fact that the judge is aware that there were several moments that she had free time to pick up her phone and dial 911 shows that she shouldn't have had to use her weapon. Because within all of that free time, you could have removed yourself from the situation. So like I said, we got to keep it factual over here. Quadajah did not follow procedure. As a concealed to carry weapons holder, she did not follow procedure. She did not follow Illinois state law when it comes to a person who has obtained an order of protection. She took the law into her own hands. We are, as private citizens, not allowed to take the law into our own hands. We are to call the proper authorities so that they can handle the situation. You don't say, you know what, I'm not calling 911, I'm just going to shoot your ass. And if anybody anywhere thinks that that is proper procedure, you are sadly mistaken and grossly wrong. Now, let's see. However, irrespective of it being the first in-person meeting between Johnson and the victim, that encounter absolutely, according to, I guess saying the word absolutely is supposed to convince everybody that this motion should be accepted, that the victim, the encounter absolutely was enough to cause Ms. Johnson to be fearful of what the victim could do to her, especially given the victim's history of violent threats against Ms. Johnson. And then she writes the date, December 4th, because that's the date in which the order, or let me see, she put the wrong year. That's the date in which the order of protection was obtained. Again, we don't see any evidence of any of this. We don't see any evidence that Quadajah was actually threatened by Romeca via phone. We know she was never directly threatened by Romeca. The defendant is alleging that Romeca contacted family members and threatened her through a third party. A third party threat. You feel that your life is in danger because you heard that somebody threatened you. You didn't even hear it with your own ears. You were told, which by legally is considered hearsay, you were told that someone you. So because you were told by your grandmama that you was being threatened, then in person when you met her, it was necessary to shoot her in the head. I don't know what type of sick bitch would do that, and I also don't know what type of sick motherfucker would agree to that. That's some sick ass shit. That it is. It just is. And it's a weak ass defense. It's a weak ass defense to say that my clients felt that, you know what? Let me tell you what a strong defense is. A strong defense is my client felt that she was in imminent danger. She felt that her life was at risk because she had had several meetings with this person before, or this person charged her with a weapon, or this person told me directly or via inbox or whatever the case may be. Hold on, y'all. Let me see something. I just got to say. Hold on. Hold on, y'all. Or whatever the case. Hold on. My bad. Let me do something real quick. Whatever the case may be, that I feel threatened in that moment. So those are strong cases of I feel threatened. I feel threatened because you had your hand in your pocket and you made it look like you had a weapon, even though you didn't, and you ran towards me. You walked towards me like you were gonna. None of that is being said. You told me face to face at one point that the next time you saw me that you were gonna unalive me. That's a strong reason to be afraid. It is a very, 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 very weak defense to say that no, I've never met her in person. We do have a long history of arguing and going back and forth. And trust me, the prosecution is going to make a big deal out of that. Romeca was not somebody that she had just met that day. Romeca is somebody that she has a history of going back and forth with. She has a history of going back and forth with Romeca on the internet. She has taken Romeca to court. She has called DCFS on Romeca and made false reports. That information was pulled up at the detention hearing. So the courts are aware that these two ladies had a very tumultuous history. So this isn't just somebody that made her fear for her life. This is someone that you actively had disdain for. This is somebody that you knew. You had disdain for this person. You knew this person. This gives motive as to why you were so reckless and so willing to fire your weapon instead of calling the police. You didn't like her anyway. You had an issue with her. You all have argued, maybe not face to face, maybe not directly, but you guys have thrown subliminals at each other. You guys do not like each other. So that is definitely going to be brought up. But to say that my defense is a third party told me that she was going to kill me is weak as fuck. And they're going to laugh her ass straight up out the fucking courtroom with that Gucci bag. With that damn motion. It's weak as fuck. Now, speaking of, hold on. I wasn't going to get to this till later. But why not? Let's do it now. Let's see. Hold on. Let's get into it now. This lady motion is using emotion. Thank you, Free Thinking, for that super chat. I appreciate you. Thank you, Demetrius, for that super sticker. This lady is using the fact that Quadajah had an order of protection against Romeca as her, I guess, reasoning as to why she had just cause to kill the girl. Okay. So I did do a little bit of research. Now let me just read this really quick. Okay. So the question is it legally justified for you to kill someone because you have an order of protection? Is it legally justified to kill someone because of a third party threat? And is fear alone enough? Number one, an order of protection is not a license to use deadly force. Number two, a third party threat is not an automatic justification for self-defense. Number three, fear alone is not enough. It must be reasonable and imminent. And when the court hears that the threat, that her fear derived from a third party threat, that is weak as fuck. That is not just cause to murder someone because you heard from somebody that they was gonna kill you. Hold on 1 second, y'all. Let me see something. Okay. Now, what in Illinois actually requires for deadly force? And then we're gonna read the code, y'all. Let me turn something off. Okay, what in Illinois actually requires for deadly force? And again, I'm going to read the code to you guys because I do have it pulled up. Under Illinois law 720 ILCS 5/7-1, deadly force is justified only if all of the following are true. Okay, so listen, y'all, pay attention. In the state of Illinois, Deadly force is only justified if all of the following are true. Meaning, and remember what I told y'all, language is very important within law, meaning that one word can change everything. The word all means that everything must exist. The word or means some things could exist. In unaliving someone and claiming self-defense, under this code, all of these things must exist. What I have pulled up on the screen, the fact that Ari is saying that her client's criminal history should have her released. In that code, it says based on the charge or her criminal history should she legally be released, not both. One or the other. Okay? But within this code, all of these things must exist. And those things are, number one, the person must reasonably believe deadly force is necessary. That is when for that one, that is when the order of protection is going to come up. That is when the threats are going to come up, how the threats were received, if the threats ever happened, if the threats are true. I personally don't believe that she was ever threatened through her grandmother. I believe she lied. And also, I believe that her grandmother, if this goes to trial, will be called to the stand. And regardless of what I believe, even if I didn't believe the grandmother lied, or the grandmother didn't lie initially, I believe that Quadajah lied in order to get the order. However, what I believe doesn't matter. What's going to end up happening is she's probably going to be called to the stand to testify, the grandmama, and they're going to ask a series of questions, and they, in the court of law, are going to get down to whether or not she's being truthful. They're going to ask when it happened, what number she called from, what telephone company do you use. They're going to pull records. They're going to do all of that. So the courts are going to determine whether or not those things happen. They're going to determine whether she ever got a call from Romeca ever. So when she gets on the stand, I think that her best bet is to not go up there and lie and commit perjury, but to tell the truth, because the prosecution is going to do an investigation. They're going to research it. They're going to pull phone records. They're going to subpoena phone records. They're going to subpoena all of that. They're going to make sure that what you are stating or what you have stated in that documentation to get that, to initially receive the order of protection, is true. So I guess we'll all find out in court if Romeca actually called her 70-year-old grandmama to threaten her. We'll find out during trial if it actually happened. Okay. Now, so one of the things is that the person reasonably believes that deadly force is necessary. The second thing that must exist is that you had to kill this person to prevent imminent death or great bodily harm. The third thing that must exist in order to claim self-defense in Illinois, under the Illinois state law, that the deadly force was justified, is that it was based on the circumstances at that moment. So the key word here is imminent, meaning happening right now, meaning that the defense is going to have to prove that when Quadajah shot and killed Romeca, that she was actively being accosted and attacked in that moment. They're going to have to fight against the footage showing that Romeca was being held in a headlock. They're going to have to fight the evidence of the footage showing that Romeca was being held in a headlock at that time. I mean, I'm interested in seeing it happen. I'm just, let's get into this too. So why is the third party threat legally weak? Number one, because Holly never received a direct threat, obviously. Now, alleged threats were relayed through family members. Okay. Not only was it relayed through family members, but it is not contemporaneous through the shooting. Holly had never met the victim in person. No evidence presented yet that the victim approached her, which it isn't. Because we do have a lot of people that scream, we present facts, we facts over feelings. No, it's a feeling that you have that Romeca busted a U-turn, jumped out, and tried to jump on Quadajah. That's a feeling, that's not a fact, because there's been no video evidence to support that. No witness has said that. There has been nothing to prove that. So that's not a fact. That's your feeling. We don't know why she busted the U-turn. We don't know if she busted the U-turn to talk to Carlos. We don't know that she even recognized Quadajah when she saw her, because she's never seen her in person. Oftentimes, people look very different in person than they do on social media. Sometimes you got to do a double take to make sure that's who you think it is. So it is an assumption to say that she busted a U-turn with the intention to fight with Holly, because you weren't there. And you don't know what. All you can speak on is action. You cannot speak on her intent because she's deceased and she cannot tell you what her intent was. So because she can't tell you what her intent was, and because you weren't there to see what happened when she busted a U-turn, it is your opinion that she busted a U-turn to fight Quadajah, unless you have the evidence to show otherwise. So we have to be very careful when we say we present facts over here, and then in the next breath say that she busted a U-turn to fight Quadajah, because that is not evident. We don't know that. That's what you think happened. Okay? So, but what we do know is that when she got up out that car, that she did not have a weapon, and that she's now deceased. And now we got to get down to the bottom of that, because if it was anyone else's daughter, if it was your daughter, your family member, and they were killed, you would want to make sure that it was justified and that it was legally done, because that's what justice is. Now, thank you, Jay Thomas. I appreciate you, hon. So again, no evidence has been presented yet. And when I say evidence, I'm not talking about the fairy tales that Holly supporters say on their platforms. I'm talking about real evidence, like it actually happened, like we saw it, we know it happens. It's a proven fact, not what other people are saying. Okay, there's no evidence that's been presented that Romeca approached the defendant. No evidence exists saying that. There's no evidence saying that Quadajah in that moment, we're not talking about what happened 5 months ago. It has to be an imminent threat. Meaning, this is what the law says. This is not what I'm saying. The law says that in order to kill someone in self-defense, it has to be an imminent threat. Meaning the threat must be now. The threat cannot be the phone call your grandmama got 2 months ago. That is not a reason to murder someone, because your grandmama got a phone call, allegedly, hearsay, you think it might be true, 5 months ago. That could be argued. It could be argued that that never happened. It could be argued that somebody else called your grandma. So you're going to kill someone because you heard from a third party that you were threatened? That's not going to fly in court with anybody that has the mustard seed or peanut M&M for a brain. You're not allowed to kill somebody because somebody told you that you were threatened. That is not going to fly, and that is not an imminent threat. An imminent threat must exist in order for you to kill someone in the state of Illinois and claim self-defense. An imminent threat is not you being threatened by a third party 5 months ago. Now, let's move on. No evidence was presented. That I heard somebody say, I think she might have had a knife. Can we please get out of La La Land and fairy tale land and stop talking about what you think she might? That was no. If somebody, I heard somebody, I don't remember where I heard it or where I saw it, but I don't know if it was a supporter or who, but somebody said, I heard the Romeca had a knife on her. Are you smoking dope? Are you on crack or something? If Romeca had any weapons on her person, it would have been in the inventory. it would have been noted that she had a knife on her person or even in her car. There was nothing within an inventory saying that Romeca had anything at all, not even pepper spray. Nothing. She had nothing. I'm kind of tired of people talking about what they think she might have did, what they think she might have had. All of these excuses to excuse her murder is sickening. So there's no evidence showing that she approached Holly. Remember, there were two people on scene. Holly was on scene and Carlos was on scene. So in order for you to say that she busted a U-turn and ran up on Holly, you would have to have proof of that, because it is very possible that she busted a U-turn to talk to her baby daddy, who she is allowed to speak with if she wants to. Right? Just like people are saying that Holly had the right to park where she wanted to, well, Romeca had a right to talk to her child's father as well. No evidence that she approached the killer. No evidence that she threatened her directly. No evidence that Romeca was armed. And no evidence that she was engaging in imminent violence at the moment that she was killed. So when it says at the moment that she was killed, that means that even if they did get into a physical altercation within those 9 or 10 minutes that the interaction was going on, after the altercation, if Romeca was being restrained, and if Quadajah was able to walk away to go to her vehicle to get her gun, in that moment, I hope you guys know what imminent means. In that moment, she was not in harm's way. She was not being hurt. She was not being attacked in that moment, meaning that in order for self-defense killing in Illinois to be justified, her life must have been in imminent danger in that moment. The fact that she was able to walk to her vehicle, the fact that camera footage is catching Carlos hitting Romeca in the face and having her in a chokehold shows that there is a point in time in which Quadajah was free, in which Quadajah was safe, in which there was no fighting going on. And in the moment that there was no fighting going on, instead of Quadajah removing herself, and removing herself means self into her vehicle, and closing the doors and windows, and staying in there with her baby, instead she walked around the vehicle, got a gun, walked back around, and shot Romeca. That's what she chose to do in that moment. So in that moment, she was not in imminent danger, which is what must exist for her killing to be justified. Illinois courts are clear. Self-defense cannot be based on past or indirect or speculative threats. It has to be a direct threat. The threat must be in that moment and not based on the past. And no, this is not my opinion. This is a fact. So if you want to argue with the law, not with me. The law says that self-defense cannot be based on past threats, indirect threats, or speculative threats. Indirect meaning third party. Third party statements are considered to be hearsay. They are considered to be unverified, and they do not establish imminence. They may explain fear, but they do not justify deadly force. Now, why the order of protection does not justify a shooting. Now, I didn't know that we would have to go over something like this, because I thought that normal people knew that just because you have an order of protection against somebody, that does not justify you pulling out your weapon and taking their life. And if you do have to pull your weapon out and take their life, then you have to make sure that if possible, you can conduct the proper steps and follow procedure before you take their life. You cannot take their life, then call the police, unless you were unable to call the police before you took their life. Camera footage shows, with even if Quadajah is not even in the camera or the shot of the camera, it shows that Quadajah had time to call the police, and she didn't. She didn't follow procedure. She didn't follow. She violated her own order. Who was that? Thank you, Robin Lotz. I appreciate you, hon. Now, it's a major misconception and needs corrected. An order of protection is a civil preventative tool. It's designed to avoid contact. It exists so parties can call law enforcement not to take lethal action. So if anybody, and this is what I want you guys to know, please, 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 do not go out there and get an order of protection and say, I got an order, so if you walk up on me, I'm gonna shoot you in the head. Baby, you're going to jail you're going to prison for a very fucking long time. It doesn't work that way. You're not allowed to do that. Don't go out here and get an order of protection against somebody that you've been hating for, that you hate or that you don't like, and that you want to do something to, and think that that order of protection is going to prevent you against the law, because it's not. It's not. You're going to go to prison. And see, that's the reason why I'm so into this story, because I really am wanting people to understand that I feel that it is dangerous to get on your platform or get on social media or whatever social media website, app that you use, and preach to people that what she did was legal, because it's not legal. And if people think that what she did is legal, they're also going to be right where she is, away from their children, sitting in jail, awaiting trial. They're going to be right where she is. So I don't want anybody to think that they can go out and get an order of protection and then go kill somebody and be protected by that order, because you're not. You're going to be away from your family for a very, very long time if you actually are taking that nonsense in and you go out and do that. Don't work that way. Now, it is also important to point out that an order of protection assumes, now listen to this carefully, y'all. An order of protection assumes that the protected person will avoid the respondent. It is only common sense to assume that if a person comes in for an order of protection against another party, that they are afraid of that person, meaning that they are going to do everything within their power to stay away from that person. So the order of protection assumes that the protected party will at all costs avoid the respondent, or at least not place themselves in a situation to see the respondent or to interact with the respondent. Meaning, if your child goes to this school, I am aware that your child goes to this school. Even if my mama lives around the corner, I'm going to take precaution when visiting my mother. I'm going to park further down this way so that you don't possibly see me. I'm going to make sure that I do my part so that we don't have any run-ins, because I'm afraid of you. I'm terribly afraid, so afraid of you that I went to a court of law and got an order of protection. So surely I'm not going to park right across the street where you could potentially see me, because I think that you're dangerous. And you said that you were going to kill me. That's what you told my grandma. You told my grandma that you was going to kill me. So surely I'm not going to put myself in a position to where you may see me. The law assumes that you're going to avoid that person, not seek or confront them, and surely not do what the witnesses are saying that you did, walking up onto her vehicle after she got in it. I'm just saying. Illinois state law does not say that if you have an order of protection, that you can use deadly force. It does not say that anywhere within the law. Nowhere. Find it and show it to me, where it says that because you have an order of protection, you can shoot the motherfucker. When y'all find that, y'all show that to me, and I'll come back and I'll retract my statements. And the Illinois state law does not say if you're afraid in general that you can shoot somebody. The order of protection does not establish that the protected person was in danger at the time. An order, and say that again, an order of protection does not establish or set in stone that at the time the person was in fear. It just means that they were in fear when they obtained the order, or should have been. And they should have been truly in fear, not just abusing the legal system. But they should have truly been in fear when they obtained the order. But it does not say that they're in danger every time they may encounter that person. So they are not protected legally to kill someone just because they have an order. It does not override self-defense standards, nor does it override the self-defense code. Did I read the code, Charity? I don't know if I did. Did I? I'm getting ready to, if I did. Or I'm going to do it again. It also... An order of protection does not eliminate the requirement of imminence. Just because you have an order of protection, it does not eliminate the legal requirement for there to be an imminent threat against you at that time. So the fact that Ari is bringing up in the motion that 5 months ago or whenever that allegedly Romeca called her Nima and said she was gonna kill her, and she heard this through her Nima, that's not strong enough evidence to murder someone. That is not considered imminence. That is something that occurred allegedly months ago. Not even in person and not even directly, but through a third party. Now, we also got to look into what is fear versus reasonable fear. And of course, the reasonable fear would be the legal term. Fear alone is not enough. The law requires reasonable fear of imminent harm. And that's where it starts to get tricky within court cases in reference to self-defense. So in reference to self-defense, it starts to get tricky because just as nobody can tell us what Romeca's intent was when she busted the U-turn, and don't listen to anybody that says that her intent was to beat up Holly, because nobody knows that. That's their opinion. Okay, it's not factual. Same goes for me. I cannot tell Holly that she did not feel danger in that moment. That is, or fear. That is when it starts to get tricky in self-defense cases. And that is why sometimes first degree is dropped down to second degree, because it is very difficult for me to tell you what you felt in that moment. Okay? So oftentimes it can be dropped down to second degree because of that fact. Now, like I said, I'm not trying to steer y'all any type of way. I'm being honest. That is true. We cannot say that she wasn't afraid legally, but common sense tells me that she wasn't. But my common sense in YouTube is a lot different than the court of law, which is why oftentimes first degree charges can be dropped down to, or are dropped down to second degree. Now, the Illinois courts are going to look at, was the threat imminent? From what we know, it wasn't. Was the person about to act? Were there other options? Was the belief objectively reasonable? Okay. However, of fear based on secondhand statements or third parties, past allegations, no direct interaction, no immediate danger does not meet that standard. So again, the fact that Miss Ari put that into motion is not going to get her released. The court does not care that she had an order of protection against her. The only people that care about that order of protection is the bloggers. The court don't care like that. Okay, you had an order of protection against her. So when you saw her, did you call the police? As a matter of fact, the order of protection is doing more harm to Holly's case than it's helping her. Because the fact that she had the order, the courts are going to ask that you follow procedure with the order that you obtained. Oh, you didn't call the police? Well, procedure is to call the police. See, when you take steps to take legal steps against someone, that person is legally expected to follow that order. But guess what? You also have a responsibility when it comes to that order. There are also rules set in place for the person that obtains the order. You cannot place yourself within a vicinity in which you know the person will be. That is going to be brought up in court. It just is. Did you call the proper authorities, and did you follow protocol for that order of protection that you obtained? Oh, you didn't? Oh, okay. Why not? This order is going to be, she is going to be held accountable for that order of protection that she obtained. Now, why all of this stuff matters for her detention and her being a threat to the community? The court obviously is going to consider the nature of the charge, which is first-degree murder. They're going to also incorporate the use of a firearm. They're going to incorporate the credibility of the self-defense claim. Risk to witnesses is also something that is going to be included. A big inclusion is a risk to the witnesses, okay? And a risk of repeating behavior. Now, we kind of went over that earlier. Let's see, where should we go from here? Okay, I did say that I wanted to pull this law code up, so let me take this down. Is this it? Did I read this already? I don't think so. I think I probably presented this in another live stream or something like that. But I think this is important to present in this live stream, because this is the code that goes over what the law says about self-defense in the state of Illinois. It's very clear, you know, it's black and white, cut and dry on what needs to happen in order for self-defense to be a self-defense claim to be valid. So a person use of force in defense of person. A person is justified in the use of force against another when and to the extent that he reasonably believes that such conduct is necessary to defend himself or another against such other's imminent use of unlawful force. However, he is justified in the use of force which is intended or likely to cause death or great bodily harm only if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or to the commission of a forcible felony. In no case shall any act, this is the part here that Quadajah is going to have to fight, okay? And the reason I say that is because based on witness statement, and even based on what we know so far as captured on camera, because again, we see that Romeca was held in a headlock at the time of the shooting. She was literally just released from the headlock when she was killed. So she has to show that, you know, she was either an imminent threat or Romeca was an imminent threat to her. And she has to explain why she feels that Romeca was an imminent threat to her and why she felt that Romeca would either kill her or cause great bodily harm. And as we've just read, we know that the previous third-party phone calls will not hold up. In no case shall any act involving the use of force justified under this section give rise to any claim or liability brought by or on behalf of any person acting within the definition of aggressor set forth in section 7/4 of this article, or the estate, spouse, or any family member of such a person against the person or estate or the person using such justified force, unless the use of force involves willful or wanton misconduct. So this means that, yes, this here, the section A is what is considered to be self-defense in Illinois. However, if anything within section B exists, that immediately cancels out self-defense, meaning that at no time during the altercation between Carlos uh she accosted or she approached Romeca. We even know that according to Carlos, that Carlos was pushing away Holly. Let's go back. Let's remind ourselves what was said now. Even witness number 1 said. Now y'all no sound. Let me see. Can y'all hear me now? Let's see. Let me look at my comments. Just if you can hear me, drop a 1. Let me type it here. Hold on. Okay, make sure connected. Y'all should be able to hear me. Okay, you can. Let me see. I'm going in and out. Okay. Y'all are saying that you can hear me, but I just want to make sure that I'm clear though. So you can hear me, but am I clear? I am? Okay. You sure? Okay. So where did I leave off? That threw me off. Oh, I was talking about the law code where it says that she cannot be considered the aggressor. So I did want to go ahead and pull up. Let me see if I can quickly find it. Y'all, I promise I'm gonna get to the whole witness thing. Just give me a moment. I just want to do this really quick. Let me go down. Where is it? Where is it? Give me a moment, y'all. Okay. I would have had it pulled up, but it's just like sometimes I think of things in the moment. Okay, so let me pull this up really quick. Okay, so I don't think people understand how important this document is. Of course, this is the detention proffer. Now, let me skim through this because I'm trying to find something. Give me a moment. Hold on. Okay, let's see. Drove his black Mercedes. Hold on, I'm getting to it. You know, before I get to that, isn't it? Do anybody else think it's kind of weird? Now, this I guess could just mean nothing at all. But do y'all think that it means anything, or do you all think that it might be kind of strange that when Carlos drove the baby in Quadajah to her vehicle, that he pulled 2 whole car lengths ahead of Quadajah? Don't like, wouldn't it make sense if you're transferring the baby and the baby's car seat into Quadajah's car, that you would park closer to Quadajah's car? Anybody ever thought about what the reason was that he parked so far ahead of her? I don't know. But anyway, let me get back to okay, so I won't say witness one said it. So I'll say, well, not witness one, I'm sorry, witness two is what I should have said. At this time, witness two, who does not know any of the parties. Now, this is one of the witnesses, of course, that, you know, Holly supporters are trying to discredit, and that the Ari is trying to discredit, because the obviously is, you know, obvious, the statement is very damaging. At this time, witness two, who does not know any of the parties, drove past victim and defendant and witness one, observing the defendant and victim standing in the street arguing, but unable to hear exactly what was being said. He observed witness one, who's Carlos, standing in between the defendant and the victim with his arms extended, and then observed the defendant advance towards the victim as witness one held the defendant back. Witness two observed witness one push the defendant away from the victim, while the victim, unarmed, stood stationary with her arms crossed across her chest. Minutes later, witness three was on an eastbound bus. I'm not going to get into her just yet. But the reason that I read that is because, as you saw in the law code in section A, it gives what self-defense claims are. And then when you look at the second part of that law code, it says what counsels out that self-defense. And that would be you being the aggressor. And in witness two's statement, it does state that he sees witness two approaching witness one, which is, you know, very damaging. Let me give me a second, child. Trying to see what the footage saw. Hold on one second. And I won't help. Let's see. After the call, victim. I just want to get to the part where first. I'm looking for something, y'all. Oh, is this it? After her 911 call, the victim entered her car. Witness 3 and witness 4 then observed the defendant approach. Witness 3 and witness 4 then observed the defendant approach victim's car and heard the defendant making threats towards the victim. Witness 3 walked closer to the incident at this time. She then observed the victim exit the Kia. When she did, observe witness 1 approach the victim from behind and place her in a chokehold with his right arm while striking her with his left. Witness 4 observed the victim unarmed with her hands in the air, trying to break free from witness 1's grasp. Now remember, witness 3 and witness 4 are not related. Okay? Witness 3 heard the defendant make threats to shoot the victim and heard witness 1 tell the victim that the defendant had a gun. The defendant then went to her vehicle and was observed by witness 3, retrieving the handgun and then stand on the sidewalk. Just the fact, let me get rid of this. Just the fact that she was able to stand on the sidewalk. This is insane. The fact that she was able to stand on, and you know what? This is what I don't want people to worry about, because drop the link. I don't. Who are you? Who is that? I'm sorry, I wasn't planning on dropping the link today. Um, uh, I typically don't drop my link. Sorry, unless it's like a panel or something like that. Defendant then went to her vehicle and was observed by witness to retrieve her hand. She stood on the sidewalk, is what they're saying. The victim was able to break free from witness one's hold and took steps away from the defendant, as observed by witness 3. So listen to this, y'all. Basically, what they're saying is that Quadajah went to go get her gun while Romeca was in the headlock. So here's the thing. A lot of people were basically saying that she was afraid that Romeca was going to, I guess, break free and attack her or whatever. But the thing about it is that Romeca was in the headlock when Quadajah left to go get the gun. She wasn't being attacked at that time. And the witnesses are confirming that when she left to get the gun, she was not being attacked. Quadajah was being restrained. I'm sorry, not Quadajah. Romeca was being restrained. Quadajah returned with the weapon, meaning that Romeca probably saw the weapon. Probably is the reason why the witnesses say that Romeca took steps away from her, because she didn't want to get shot. She took steps away from the defendant, as observed by witness 3. Witness 3 then observed the defendant point her handgun at the victim, walk towards the victim, and then fire multiple times at her. Now, all of these things can be verified. Huh? What is she talking about? Oh, okay, I see. All of these things can be verified, obviously, by ballistics, and that's the reason why the crime scene should have never really been tampered with. There was so many people just walking around, and and all of this. They did a piss poor job of preserving that crime scene. When you shoot somebody, where the bullet casing lands is very important, because it shows where the shooter was standing. It shows where the person was when they fired. One of the bullets was on her windshield. That shows that when she was fired, she was right next to her vehicle. Could have got in her vehicle. It's a lot to this. It's a lot to this. Now that's just, I wanted to just read that, because again, these things are being stated by the witnesses. The law code clearly states that she clearly was out of her legal rights in regards to it being self-defense if she was the aggressor. More than one witness observed her approaching the victim, meaning that she was the aggressor at some point during that altercation. Okay. Now let's get into something else. I want to talk about. Let me look at some. Yeah, it really was Raquel. She said it was mofos all up and through the crime scene. If she was blocked in, she could have went and sat in Carlos' car. But she wasn't blocked in, right? You have seen the aerial photo of the crime scene, right? There, a lot of the people that are in support of Holly are lying and saying that Carlos moved his vehicle up, but we know that Carlos didn't move his vehicle up, because Carlos actually, according to the proffer, reported to Chicago police that initially when he pulled up, he pulled two car lengths ahead of Quadajah. When you look at the aftermath of the crime scene, his car was still parked 2 car lengths ahead of Quadajah. He never moved his vehicle, meaning that Quadajah could have gotten out. When you look at Romeca's vehicle, her bumper is at the very back of Quadajah's car, meaning her car was not side by side with Quadajah's. Quadajah had plenty of space to pull out. Should we pull it up? Hold on, let me see if I can find the aerial footage of let me see. Should we pull that up? We kind of did already, but we can again. Hold on one second, y'all. See if I can find it really quick. If I can't find it real quick, then I'm just gonna move on. Yeah, Miss Quadajah, that can no longer be used as her defense that she couldn't get away. That's not a defense at this point. And I'm sure that the picture of the aerial footage of the way that they were parked on the crime scene, I'm pretty sure that that's going to be used in evidence as well, because in the motion, Ari states that Quadajah was blocked in. Quadajah was not blocked in on that day at all. She chose to do what she did. She did it because she wanted to and gotten in her car. Damn, let me see if I can find this thing. What's the let me see. Let's see. Damn, somebody can send me the aerial footage so I don't gotta dig through all of this stuff. It'll be greatly appreciated. Let me see. Because I wasn't prepared to show that, so I don't have it pulled up. Okay, I'm not gonna spend too much time on that because I can't find it. If I have it, but I just can't find it at this time. Hey, Danny. Oh, here it is. Okay, so let me pull this up real quick. I forgot who just asked that, but let me pull this up really quick. So this is the aerial footage of, or not footage, I'm sorry, the aerial picture of the crime scene here. Now, if you can you guys see it? Oh, I can't share the screen. Why not? You guys can't see that? Let me see. Why isn't it letting me share? Damn. Hold on one second, y'all. Let me see what's going on here. Hold on. Oh. You know what, y'all? Let me leave out and come right back and see if that might help. Give me a second. I don't know. It's not letting me share anymore. That sucks. I don't know what happened. But maybe I'll just post it on my Facebook and y'all can go look at it from there. Just go look at it from there. I'll repost it on my Facebook. Let me save this. Y'all can look at it from there. But for some reason, this Restream is not allowing me to share right now. Not exactly sure why. But on the photo, the aerial photo, because I'm looking at it right now, it shows a bunch of emergency responders next to the vehicles in question. Okay. Carlos is parked very, very far in front of Quadajah's car. I don't know why he parked like that. I don't know why he would park that far in front of her car to transfer the baby into another car. That's kind of strange. And then Quadajah is parked on by the sidewalk. Romeca is parked almost behind Quadajah. Okay, she's not directly side by side with her, and there's a big space between Carlos and Romeca, giving Quadajah a huge space in which she could pull through, but she just didn't. So that defense, that's why I say the motion is weak. A lot of the things that she's bringing up in the damn motion have already been debunked online. So I don't understand what that's about. Let me try one more time. No, still not working. Okay. So let's move on. So I do, because we've been on for a while, I do want to get into the, is it legally wrong to is it, oh, thank you, Anthony, I appreciate that. Is it legally wrong to post witnesses' pictures on social media as a content creator? Is that legally wrong? I want to get into, obviously, is it legally wrong? But I also want to talk about, is it morally wrong? Because a lot of people will say, oh, well, I have rights to post it online. Legally, I have the right to do that. So nobody can say anything to me about doing it because legally I have that right. Just because something is legally right does not always make it morally right. I've said this in so many different live streams. Just because you may have the legal authority to do something does not always mean that you should. It does not always mean that it is something that you should do. And because we're all smart, grown adults, we understand that even though I can do something, that I shouldn't always do it just because I can do it. And it really speaks on a person's character and level of morality when they use the legal excuse, even though you know that posting somebody's picture and legal name could in some way bring them harm. And as people that parade around like, you know, we are these intelligent, informed, professional content creators, and we cannot then turn around and say, I was ignorant to the fact that that may have brought harm to that young lady. It's either you're intelligent, you're smart, you're aware, or you're dense. It's one or the other. It's common sense that within a murder trial, if you post the main witness of the state of the prosecution on social media, potentially cause harm to that person. So whether or not you're saying it's legal, which we know, I'm going to get into that because it's not legal. We're going to get into that in a minute. It's not legal. Even if, you know, you were, because I'm going to tell you it's not legal because intent matters in the law. Your intention matters in the law. Whether or not malice exists or not is important in the legal sense, in legal terms. So let's get into it. Is this legal? And I can't screen share for some reason. My restream is tripping, so I just gotta, you know, if I want to show you, I can't show you guys an article or whatever. I just gotta read it. Is it legally wrong in the state of Illinois? Is it illegal in the state of Illinois? Now, we know that the motion is a public record, meaning that legally we are able to read a public record or show a public record, which is why when they, I have a big hater here on YouTube that just is super intimidated by me. So while I was live, they put in a privacy complaint, but YouTube took the privacy complaint off and replaced my live back onto the platform because legally I had done nothing wrong. I had not presented any private information. It's a whole public document. So that's why my live stream was placed back onto the platform. So we know that the motion is a public document. So we're going to talk about public records versus responsible use in Illinois. Court filings, motions, witness lists, pleadings are public records once they are filed. Mug shots and arrest records are also often publicly accessible. Assessing this information is generally legal. However, what crosses the legal line, even when information is public, is how it is being used. Potential legal problems include witness intimidation or harassment. Illinois law takes that very seriously. Publishing a witness's identity, photo, and criminal history with commentary, meaning if you post a mugshot of that person and say, ha ha, really? This is your witness? She's a criminal. If you post commentary with the witness picture, that could discourage testimony. It could invite harassment, and it could also influence public perception of that witness's credibility. Okay? Also keep in mind who posts the witness's pictures or legal name. If you are a commentator that is covering the story who has made it very public that you are leaning towards the side of believing the defendant, and then you post the state's witness, that shows that you have intent. It shows that you are trying to form a narrative about that individual. Now, it doesn't really matter if you believe it or not. If you don't believe it, we have this thing called the World Wide Web, where you can actually get onto this website called Google, and by golly, it's free. And when you get on there, you can literally type in and ask Google, is what I did legal? And Google will let you know whether it's legal or not. And I don't want to discourage anyone, it's free. You don't even have to pay for Google. You could just go on there and ask, was it legal? And of course, nobody can tell you what your intention is. However, what can be done and we're going to get into that also, because I happen to know that it was already reported to the proper channels that was done to the witness. I'm just waiting to see what's going to happen about it, but it was reported, and the right people heard about it already. But if that witness, let me not say that, let me get back into this. Okay, so publishing a witness's identity, photo, and criminal history with commentary can discourage a testimony, invite harassment, influence public perception of credibility. If content is framed in a way that discredits, threatens, or pressures the witness, it can fall under witness intimidation. Mind you, witness intimidation in the state of Illinois, and of course, I encourage all you intelligent people to please follow up with what I'm telling you onto Google, because that's also, a public website where you can verify whatever I'm saying here. Witness intimidation does not have to involve a witness being threatened. You do not have to directly threaten a witness for it to be considered witness intimidation. It can also be considered obstruction of justice and indirect harassment. This is especially sensitive before trial, which is exactly where this case is, right before trial. Violation of court orders and defamation risk. I'm not going to get into that part. What is usually not illegal? So what's not illegal is simply discussing the motion, presenting the motion to your audience. There's nothing wrong with doing that, especially if you take the time out as a responsible content creator and redact the witnesses' names from your presentation. Then no, that is not considered to be illegal. It's not illegal to refer to a witness by role rather than name, i.e. witness 1, witness 2, or witness 3, versus saying Amy Brown. You say witness 1 to protect the witness as a responsible creator. Unless, of course, your goal is to have the witness harassed, because if that's your goal, then, posting the witness would do just that. It is it is usually not illegal to analyze arguments without exposing personal data. So legality depends less on access and more on intent, framing, and effect. So when people say, I didn't do, it wasn't illegal. No, the actual act of posting the witness is not illegal, but your intent behind it can be seen and become illegal if proven. For instance, if you post a witness on your platform and then people go throughout your social media history and see you discrediting, dragging, making fun of, or doing anything to discredit the victim, then they see that you have chosen a side here, meaning that you have intent to make this witness look a certain way because you are doing commentary in defense of the defendant. So if there is a history that can be found of you doing commentary in defense of the defendant, then yes, it can be considered illegal because the law focuses on intent. Okay, not just the actual action. Now that we got that out of the way, if you hear anyone say that it is not illegal to post a witness, please explain it is illegal in certain cases, depending on your intent behind it, especially if you're a content creator. If you're a content creator and you are posting a witness in an open murder investigation and you are actively, openly, and publicly in defense of the defendant, you are putting the state's witness picture up publicly along with her first and last name. It appears that you are intentionally trying to get her to be harassed. You are harassing her. You are bullying her because she's speaking on what she saw. It is not our job as content creators to put anybody's life in jeopardy because they're speaking about what they saw. And see, I just seen a video of, whose was it? Harmony's. I think it was Harmony's video where she kind of, and I would share some of it, but my screen share messing up. But she basically said, you know, and you have to know your limit as a creator. If you know that doing something could potentially have someone murdered, witnesses get murdered every day to shut them up. These witnesses are very important, and what they're saying can be very detrimental to the defendant. These people can be killed. Know that. What type of human being would know that if I put this on my platform and I have thousands of people following me and thousands of people that I know the type of danger that this young lady can be placed in, and that is completely evil. It's evil. And honestly, it kind of makes sense as to why some people are in defense of the murderer. Because I don't think they think murder is really that big of a deal. Because if you did, then you wouldn't be posting the state's witness on a public platform with her first and last name. Because that surely can be looked up. Her address surely can be found. She could walk out of her house tomorrow and get a bullet in the head because you posted her picture with her first and last name. I could type her first and last name in right now and get her address and phone number. That's the type of danger that you're placing this young 20-year-old lady in. But hey, doesn't matter because it's legal. So whether it's morally right or wrong, it is not going to be questioned or put into question. That doesn't matter. The law says I can do it, so damn it, I'm going to put her life in danger. That's all that matters. Okay, I guess. The witnesses are not defendants, okay? The witness is not on trial. It does not matter that the witness has a history or a background or has done anything illegal in the past, whether or not the victim got into 20 fights in the past, whether or not she stole things in the past or committed crimes in the past, does not negate what she saw on that day. And it does not make her, it does not mean that she's not credible because she has a mugshot. If that's the case, then Carlos is incredible because he got more mug shots than anybody in the damn whole damn situation. He's a 3-time convicted fucking felon. So if we gonna believe Carlos' statement and we're gonna believe what Carlos say happened on that day, then why does it matter that the other witness has a mug shot? Carlos got about 5 of them. What does that matter? That she has a background. Your boy got a background. So let's talk about what matters here. Okay, their past is not automatically relevant to the facts of this case on this day. So dragging their mug shots onto social media knowingly, because I'm hoping that we're not dealing with idiots. I'm hoping that these are intelligent people that are running these platforms. Because if not, then I'm afraid. Because I think an intelligent person would know that posting a state witness in a viral case would invite harassment. I'm sure that it could possibly intimidate further witnesses that may want to come up and step up and speak on what they saw that day. I'm sure it discourages people from cooperating with law enforcement further. So, number one, it's illegal, especially the way that it was done is illegal. Whom it was done by makes it illegal. The malice behind it makes it illegal. And it was morally wrong. And I said what the fuck I said. Now put it in your motherfucking corn pipe and smoke it. I said what the fuck I said. And ain't nobody gonna do a fuck thing about it. It was morally wrong and it was illegal. Next. Selective exposure is manipulation. When creators highlight a witness's past, ignore relevance to the incident, frame it to support a narrative that is not reporting, that's character assassination. Okay? So we covered that. We know, and then, again, I know that I'm going to just read this. So let's talk a little bit before we end this about witness intimidation, okay? Let me see. In the state of Illinois, and this is written in law, witness intimidation is a class 3 felony. Just to let y'all know. It involves threatening harm, false accusations, exposing someone to contempt to make them act and refrain from acting. It carries between 2 to 10 years in prison. Okay? While obstruction of justice is a class 4 felony, meaning you're knowingly interfering with law enforcement or court processes, like hiding evidence or giving false info. That's something different. Okay. So the definition of intimidation is threatening to commit a felony, misdemeanor, falsely accusing someone, exposing them to ridicule, or taking official action against them to compel or prevent an act. So again, threatening to commit a felony, misdemeanor, falsely accusing someone, or purposely, knowingly exposing them to ridicule, or taking an official action against them to compel them to prevent an act. Meaning you're doing things to prevent them or to discourage them from continuing to speak as a witness. You're exposing them knowing that they are a state witness in a very big viral internet case that you're covering in defense of the other party and posting their information for ridicule. Especially if you have a caption above the picture laughing at the witness saying that she's not credible, that further shows that it was posted to ridicule the witness. Now, I've already told you guys that all of it has already been reported to the courts. I was informed of that this morning. So it's all been reported to the courts. The action has been reported to the courts. Who did it has been reported to the courts. The witness apparently is aware that it happened as well. So whatever action that witness wants to take for her life being put in danger because people are mad that Quadajah's murderous ass is locked up, hopefully she takes it to the furthest extent of the law. I hope she tell them that she's scared to death for her life because of what was done on the internet. Further, they're not going to let Quadajah out because of what was done on the internet. Now that they're aware, now that everybody's aware, because one of the conditions and one of the reasons why Quadajah was not released on her detention date was because they said they wanted to protect the community and the victims. Verbatim, the victims. So how dumb was it to take a picture of the victim and post it on a public platform with their first and last name where they can be looked up and found, but then turn around and say that you're in support of Holly being released? How? One of the reasons she wasn't released was because they're afraid for the victims. So then you take your smart Einstein looking ass and actually post the victim? You thought that was a good idea? They're not letting her out. They wasn't going to let her out even if the victims wasn't posted. But that surely did not help. It surely didn't help. What is the motive there? Are you trying to get the witness killed? You know, this is the city of Chicago. You know, this is the city of Chicago. Somebody will kill you. Somebody will murder you, take your life for first, not even going to court. Somebody will kill you for talking to the police. So you post a 20-year-old kid's picture on a platform as a grown fucking adult and put their life in danger. Sickening, disgusting, sickening. And I'm not very convinced that people are not aware of the gravity of their actions. I think that people know that by posting her, that it will put her life in danger. See, this is the reason why people get the same people are saying facts over feelings are putting their feelings way too deep into this. Because if you are so deep in your harm to come to somebody behind this story that you have nothing to do with, I think you're too invested. Because it's never that serious to put somebody's life in jeopardy because somebody that you're defending on YouTube is in jail. It ain't that deep. It's not that deep. And I hope the proper channels are gone through to make sure that doesn't happen again to any other witnesses, because there are other witnesses. Now, and then I saw a lot of people saying Ari should have redacted them. I think she should have too, but even so, people should have enough common sense not to put that out to the public purposely. Because let me tell you, so when I did my live stream, I said, I'm going to take I was reading the documents and I said, okay, time to take them down. Because now we're getting into an area on the documentation where there is witness names. So I took it down. And when I referred to the witnesses, I purposely referred to the witnesses as witness said or witness one said. I did not read their names because that's common sense. Even though it is publicly available, even though the information is publicly available, as a creator, you have the responsibility to not put someone's life in danger. Because how would you feel if by your action that the very following week somebody loses their life and then you know that you posted them on your platform? How would you feel? Some people may not give a fuck. Some people don't give a shit. You know, some people like, oh, well, or some people probably be happy that something happened to her because they didn't want her to testify against Holly. Some of these creators are that sick. But I would hope to believe that you wouldn't want something to happen to her and that you would feel bad if by your action that something happened to her. So this is not an argument. This is common sense. Common sense says that was a dangerous thing to do and it was a reckless thing to do. And if you ever witnessed a crime where somebody's life was taken and you don't feel that it was justified and you spoke as a witness, would you want to be exposed to the public and your life and your family's life to be put in danger? So why would you do it to somebody else? This is the reason why people witness crimes every day and people don't get justice, because somebody's always watching, but people are oftentimes very afraid to come to the forefront. And now I see why. Now I see why. Because when witnesses come forward and they speak, you got people in the background that's mad that the witness is speaking, and now you feel that the witness should be punished for speaking. This is why people don't come to the forefront. This is why there's so many cases out here where people have not received justice, not because nobody saw what happened, but because people are afraid to say what happened. Because the moment I say what happened, people are going to say I'm lying. People are going to say it didn't happen. I'm going to be villainized. I don't want to have anything to do with it. That's the reason why so many cases go unsolved. That's the reason why there are so many cold cases, especially in the city of Chicago. People scared because you got ignorant motherfuckers that'll go and put your information out, especially, mind you, and it's a viral case. It's not just a regular case. The whole world looking at this damn case. Content creators all over the world talking about this case. It's not just about Chicago no more. You got people all over the world looking at this case. People from all types of different states is in my chat right now. So this is a viral case. I feel, in my opinion, that people should have more class and more dignity and be more responsible when reporting. It's not that serious just because this case has gone in a direction that does not fit the narrative that you were feeding your audience, that you should then put somebody's life in danger. It's not that serious. I don't think it's that serious because regardless of what any of us say, what happens to Quadajah legally is what's going to happen to Quadajah. It doesn't matter who likes it. It just doesn't even matter. She's going to get what she deserves. She's going to face whatever consequences that she's legally supposed to face. Does anybody else's life have to be taken in the process? One life has already been lost. Do we need to lose more lives in the process? I don't think we should. I don't think that we need to lose more lives in the process. I don't think a 20-year-old, because I'm 38 years old. To me, a 20-year-old is a kid. And according to what I've seen, the witness is 20 years old. Is it worth putting a 20-year, as a grown-ass adult, is it worth putting a 20-year-old kid identification up and put a child, because that's what a 20-year-old is a fucking kid. Put a kid up on your platform and potentially have that girl killed by identifying her. Is it that deep? We should be more protective than that of each other as humans. So I find it very disgusting, and I don't really give a fuck who doesn't like it. Go live about it. So fucking what? I don't care who don't like it. I think that it's disgusting to purposely, knowingly put someone's life in jeopardy. I think it's gross. I think it's demonic, like I've been saying for a long time. Only a demon would do that. Only a demon would knowingly put somebody's life in danger and put somebody at risk of being murdered. I don't know anybody that's not demonic that would do that. I don't know anybody with any conscience that would do that. I just don't know. Do you all know anybody that has a conscience that would do something like that? Because wouldn't you say, if I do this and she gets killed, I think I would feel bad? Most people with a soul would say, if I post her and she get killed tomorrow, I'm going to feel like a piece of shit, so I'm not even going to do that. But I mean, if you don't have a soul, you got a black heart and you're a demon, you might do it because you don't give a fuck. Yeah, that's my opinion on that. Like I said, it's wrong legally, and it's wrong morally. Now, I'm about to get off because it's getting late. Thank you, everybody, for listening to my commentary, for everybody that assisted in helping me to reach my goal. I do appreciate you. Make sure that before you guys leave, I know I always say the same thing because I gotta say it just so y'all don't forget. Make sure y'all hit the like button. Make sure that you subscribe to my channel if you're sitting in the bushes. Even to the people sitting in the bushes pretending that they don't like me. I know you've been here for the past 2 hours and 23 minutes, hanging on to my every word. So you may as well go ahead and subscribe as well. Don't forget to hit the notification bell so that you can be notified of the next time that I go live or the next time that I post content. When I end the live, make sure that you hype me up. Thank you guys so much. I'll see you probably tomorrow or Wednesday. All right, y'all. Peace.
I got a lady. Hey, I got a lady. Hey, name is the upper echelon. She a debater, baby. She can give it to you straight, no chaser. She got the smarts. She got the heart. She got the confidence, baby. Baby, she the upper echelon. You know you intimidated.